Sally Pung, Christopher Smith, and the head of the Elder Abuse Task Force, Catherine Barron, is here to share the great work that's happening behind the scenes in a bipartisan fashion to move us forward on our quest to prevent elder abuse here in Michigan. Did I miss anyone, just in case? Good. Did I get everybody? Okay, just wanted to make sure. Okay, so again, after more than 2 years of work, the legislation we are announcing today is another example of how the Elder Abuse Task Force is laser focused on making a difference. And let me say this. This has truly been a bipartisan effort. And as I've always said about this, if we can't come together to support seniors and other vulnerable adults in our state, I mean, what is the point of having a state government, right? And we all agree on the incredible importance of this work. And I am just so delighted at the effort that's been put in by both sides and by everybody who has been involved in putting this package together. And, you know, at the heart of it, it doesn't matter what our political parties are, or our race, or gender, or ethnicity, or, you know, sexual orientation, et cetera, et cetera. You know, the one thing we all have in common standing up here is, the good Lord willing, we're all going to be seniors one day, if we're not already. And we all want to be treated with respect and dignity. And that's what this is all about. So these bills are a direct reflection of the task force's first set of initiatives, which will be provided to those present today and available to the public online via mi.gov/elderabuse. And in just a moment, you'll hear from Justice Kavanaugh, Representative Graham Filler, the chair of the House Judiciary Committee, and Senator Roger Victory, the chair of the Senate Judiciary and Public Safety Committee. And you'll also hear from 2 task force experts whose life experiences illustrate just why this legislation is so important. But first, it is my great pleasure to turn it over to Justice Megan Kavanaugh.
Thank you. Thank you, Attorney General Nessel, for the opportunity to join you for this important event. When we first gathered here to kick off the work of the task force, we were very optimistic about making it to this step, but we also knew that getting here would be challenging. Why? Because other work groups and task forces had made recommendations that never actually became a reality. So when we started this process, we vowed to focus on not just recommendations, but on results. And we are here today taking another step towards those results. Little did we know that a pandemic would get in the way of progress, but we did not let the virus stop us. The work continued, we adapted, we worked differently, and I commend everyone, especially the AG's team, on all their hard work to get us this far. And thank you to the members of the state legislature who have listened carefully to the task force and have responded. I'm also thankful to the task force and the Attorney General for open, ongoing, and inclusive process, and for working to educate the public about guardianships and the important works of our probate courts. With the reforms we propose today, probate judges will have additional tools in the law to make sure that the rights of people with guardians are protected. If there's one thing I heard over and over serving on this task force, is that pretty much by definition, being a guardian or a conservator is not easy. It's an extremely important responsibility, but one which can be difficult to navigate. That's why training, transparency, and certification is so very important. Just as important, I want to emphasize how much I admire and commend family members who step up to be conscientious and dedicated guardians. It is an incredibly tough job, and if a court chooses a professional guardian over a family member, the reason for that decision should be transparent and should be supported on the record. Now, I realize that every family is not perfect. Mine certainly is not, and the decisions regarding guardianship and conservatorship are some of the most difficult any family can have to make. That's why our job to make the process more accountable, more accessible, and more focused on protecting Michigan's vulnerable residents is very important. So I just want to finish with a quick story about my family. Every time I come to this building, the Williams building, I, of course, can't help but think of G. Menon Williams, Soapy Williams. Spent a lot of time with him as a kid. He was a mentor to my dad when he first got on the court in the early 80s. And we all remember Soapy's signature bow tie. But some folks might not remember that my uncle, Jerry Kavanaugh, who was the mayor of Detroit, ran against Soapy Williams in 1966 for the U.S. Senate. And so while Soapy had his signature bow tie, my uncle had a different campaign gimmick, and it's metal clickers, which I have here, that he distributed to his supporters to make noise during his campaign. It literally is from 1966. I had to take it from my dad. So my Uncle Jerry didn't win that election, but I remember hearing about these clickers. And I tell this story because it reminds me that the best way to make change happen is to make noise. And throughout this process, concerned people did exactly that. They made noise. They came to hearings. They wrote letters. They talked to the media. They talked to elected representatives. And I'm here to say that we heard them loud and clear. Results are what matter, and we are getting closer today to deliver on those results. So a big thank you to the public, to everyone in Michigan that did show up and had your voice heard. Thank you. And now I would like to introduce Representative Filler.
My name is State Representative Graham Filler. I'm the chair of the House Judiciary Committee, and I'm proud to, along with my colleagues in the House and the Senate, take the lead on these important bills to stop elder abuse in the state of Michigan. Now, I'm a former Assistant Attorney General, served here in this building, and I worked on behalf of elderly folks who were taken advantage of. I want to give you an example. A contractor was accepting payments from elderly individuals and then not doing the job promised. I called the contractor and said, really simply, you've taken advantage of these elderly individuals. Either you refund the money or you do the work, or I'm going to use the full weight of this state to prosecute you. And you know what? He did the work promised, and he paid back a lot of the money too. The lesson here, this state should protect its most vulnerable. So why am I standing up here holding the photo of a fence? In 2018, Bob Mitchell and Barbara Delbridge were put under the care of a guardian, who then put up a 6-foot-tall privacy fence around their home, presumably to slow down access for Bob and Barbara to see their family. Eventually, these guardians were removed from caring from Bob and Barbara due to their abuses. Elderly folks in the guardianship system should not be fenced in. That was insanity. And you'll hear from a family member involved in that process and her support of these bills. This case seemed to shock the conscience and spur on discussions about how to improve the guardianship system to ensure that bad actors can no longer take advantage of elderly or disabled individuals. What do these bills do? Some specifics. Increased trainings for guardians, more procedural safeguards for when a guardian is appointed, more protection for the ward's property, transparency for how a ward's property is being used. This is not fly-by-night legislation. These bills come from years of discussion and a task force and nonpartisan review. My House committee will be holding hearings in June and beginning the debate and legislative discussion. My promise to elderly and disabled Michigan citizens in the guardianship system is that this legislature will stand with and protect you. Thank you very much, and I'm proud to introduce Senator Roger Victory, my colleague in the Senate who chairs the Judiciary Committee. Thank you.
Thank you, Mr. Chair. Good morning, everyone, and also Attorney General did mention a couple of fellow senators who are not here. They're actually still in Judiciary Committee as we speak, but we do have Senator Ruth Johnson joining with us today. Attorney General Nessel, Representative Filler, thank you and all the members of the Elder Abuse Task Force for all your time and dedicated work to protect Michigan seniors. We owe seniors so much. They have guided and paved the way for our advancements and success, both for our overall society and throughout our individual and personal relations. It is important that we step up to take on one of the most important roles in our society and in state government to protect our most vulnerable citizens from harm. Far too often, these problems have come to light after the emotional, physical, and financial harm has happened. We must look for proactive solutions that will safeguard our seniors from all those that seek to take advantage of them during times of confusion and emotional, physical distress. I look forward to working with the Attorney General and my legislative colleagues on both sides of the aisle on this common goal to ensure our seniors' best interests are always the top priority, and that our society works to better protect our vulnerable seniors from those that would do them harm. And it is now my privilege to introduce Sally Pung.
Good morning. I'm Sally Pung, the State Long-Term Care Ombudsman. The Michigan Long-Term Care Ombudsman Program, which I direct, advocates on behalf of residents in long-term care settings, including nursing homes, home for the aged, and adult foster care homes. We strive to improve the quality of life and quality of care for those residents. I'm particularly pleased to be here today because many of the residents we serve have guardians and conservators. Guardians and conservators often are granted the power and responsibility to make all personal, medical, and financial decisions for another person. Some residents report being well served by these fiduciaries, but many residents are not as fortunate. I've talked with many residents who have never met their guardian or cannot reach them when they need to. Some residents report that guardians fail to meet their basic needs, like providing socks or arranging for haircuts, very basic needs. They don't follow up on the necessary medical care or restrict the resident from participating in meaningful activities or communicating with their family members. Residents also complain that conservators often fail to explain how the residents' funds are being used. Because ombudsmen know the incredible difference it makes for residents to have a capable, caring, and knowledgeable guardian or conservator, I was eager to work on the Elder Abuse Task Force's initiative to require professional guardians and conservators to become certified. This initiative includes establishing minimum training requirements, professional standards, and bonding requirements. I wish to thank the Attorney General for including this critical and crucial certification requirements for guardians and conservators in this legislative package, as it will have a positive impact on some of the most vulnerable citizens. Thank you. With that said, I'd like to turn it over to Christopher Smith from the State Elder Bar Law Section.
Thank you, Sally. My name is Christopher Smith, and I'm an attorney and the task force representative for the Elder Law and Disability Rights section of the State Bar of Michigan. The Elder Law and Disability Rights section of the State Bar of Michigan consists of 1,181 volunteer attorney members. And the position that I'm about to express is the position of the section and not necessarily the State Bar as a whole. We see too many Michiganders lose their due process rights simply because they become old or disabled. And as has been said, that could be any one of us. We applaud the legislation's efforts to ensure that every Michigander who may be subject to a guardianship petition has their case fully heard and fairly heard in court, and that alternatives to guardianship are fully considered before a guardianship is put in place. And if a guardianship becomes necessary, our current statutes are supposed to ensure that our preference, who we want to serve as guardian, is given first priority. And if we're not unable to express who we would want, that our family members and those closest to us would have next priority. But too often, when things just get a bit complicated, that priority is skipped over. This legislation does two relatively simple, very important things. First, it clarifies, it puts into statute the reasons why somebody should be skipped over in that priority list. It sets out the rules so everybody knows and everybody can make their case in court transparently. And then, if somebody is not suitable to be guardian, it asks the court and requires the court to lay down specific facts on the record as to why those closest to us are not suitable to be the guardian. The legislation would ensure that if we must be subject to guardianship, those closest to us will always be given first and adequate consideration. On a brief personal note, I want to vouch that the proposed legislation is the result of 2 years of efforts by dozens of task force members who have literally put in thousands of volunteer hours. I commend my fellow task force members, Attorney General Nessel, the bipartisan set of legislatures that you see here today, for being bold. We could be here announcing a report that would just sit on a shelf. We're not doing that. We're proposing specific legislation, and making fundamental changes to legislation is hard but important, because this could be us someday. Thank you, everyone, for your efforts. Now I will turn it over to Gretchen Summers, who will briefly share her family's experience with court-appointed guardians and conservators, and was left with the power to make, was left without the power to make all medical and financial decisions for her aunt.
Hi there. Thanks for having me. Get my nerves out here. Anyways, I'm Gretchen Summers. I'm here on behalf of my aunt and uncle, Bob and Barb Mitchell. Barb and Bob are no longer with us. Barb passed about a year after she was put in an erroneous guardianship, and Bob passed about 6 weeks after her. So quick background on Bob and Barb. They lived in a small house in Utica for over 35 years. It was one of those neighborhoods where you know everybody. Everybody kind of looked out for each other. It was a very quaint neighborhood, and Barb and Bob were very frugal. They didn't ever buy new cars or new clothes or anything. That they saved for their retirement. And in doing so, they attained a pretty large and impressive nest egg. They weren't flashy people or anything like that, so looking at them, you would have never known that. Barb and Bob were incredibly close, and Bob had 2 kids from his previous marriage a long time ago. Barb never had biological kids, but Bob's kids, Marcy and Corey, were just like Barb's kids. And Marcy and Barb were pretty much like best friends. They were inseparable. So in that aspect, it made perfect sense for Marcy to petition for guardianship. She was an integral part of their lives, knew everything about them, and all the family was behind her. No one contested it. No one else petitioned for guardianship. And in fact, the guardian ad litem that interviewed Marcy highly recommended her to be Bob and Barb's guardian. We assumed things would go slowly at the hearing on November 28th, and unfortunately, we learned that was not the case. And over the next 6 months, we got a crash course in this probate court corruption. The judge that was assigned to Marcy's hearing was Judge Catherine George, and she ignored statute and erroneously appointed a for-profit guardianship called Caring Hearts Incorporated of Michigan to be both Barb and Bob's conservator and guardian. Caring Hearts was started in May of 2018, and it was owned by Kathy Kirk and Anthony Pung. Neither of them had any medical background, no elderly care background, no elder advocacy. So that's why this training is so important. I could go start a guardianship company when I leave here and be in charge of your family members' well-being, their financial history, their medical history. I could issue a DNR on that family member if I wanted, which actually Caring Hearts was trying to do, and they did bill Barb and Bob's estate for researching that. Things went from bad to worse. First, Bob and Barb's home phone was disconnected. Their cell phones were confiscated. Their mail was forwarded to Kathy Kirk's office, so we literally had no way to contact them, nor them us. Next, we noticed a privacy fence being installed. Now, they had a chain link fence around their whole house because they had a dog, so there was really no need for another fence unless you were trying to keep something in. This fence was 6.5 foot tall solid wood. I'm not talking slats in between it like a quaint little, this was a solid wood fence. And I have a picture of Barb trying to reach through and my mom on the other side bawling. And that was when I thought, this is not right. We have to do something. I just can't let them take my family members and we never see them again. When we tried to visit, they called 911, and actually our family had 911 called over a dozen times on us with no charges because we weren't doing anything wrong. So the care they received from Executive Care, which was also Kathy Kirk and Anthony Pung's care business, was subpar. Barb fell and broke her hip. She had 2 more falls requiring sutures and staples in her head, and again, we weren't able to be with her when those things happened. So just as Justice Kavanaugh said, we decided to make some noise. We had a clicker, and I thought, we got to use our voices to fight for not only Bob and Barb, but for other people that this is happening to, because this was not an isolated incident, as we found out. So thankfully, Heather Catellos from WXYZ7 began to cover our story, and we're forever thankful for her, because at that point, that's when the AG's office intervened. So then in May, Caring Hearts resigned, and we were finally able to see Bob and Barb after 6 months. So this whole ordeal was quite a nightmare, to say the least. We were robbed of precious time we'll never get back with Bob and Barb since they are no longer with us. And our hope is that no family ever has to go through what we did. Our probate court should be a safe place for elderly individuals and their families, especially seniors. And we hope that with these new legislations that will make that happen. Thank you for having me too.
Thank you so much for sharing that story with us, Gretchen. And as you indicated, you know, hopefully what we're doing here today and what the legislators behind us plan to get accomplished will mean that no other family has to go through what your family went through. So thank you very much for sharing your story. And thank you to Sally and Chris for your hard work on the task force. And thanks too, of course, to Justice Kavanaugh, again, Rep. Filler and Senator Victory, and their legislative partners who are here from both sides of the aisle. Again, we are deeply grateful for your continued partnership with the task force and to stand with you here as these bills move forward. On a separate note, beyond, of course, thanking all the members of the task force who worked so hard, I'd like to give some shout outs to my amazing staff at the AG's office who've done such an incredible job. And I see some of them here today. Mitch Albers from our legislative team, Dave Tenay from Healthcare Fraud, Tony Harris from Health, Education, and Family Services. Did I get that right? Okay. And Kristen Steindorf from Financial Crimes. And thanks again so much, of course, to Catherine Barron, who's our chair, and Scott Teeter from Financial Crimes, who was our former chair. Thanks you so much to all you guys for all your incredible work. And I continue to be blown away by the amazing work of all the attorneys here at the Department of Attorney General. So anyway, these proposals, as we indicated, they'll help ensure our guardianship and conservatorship system provides vulnerable Michiganders the true safety net, not a trap, and ensures our probate courts use their fiduciaries only to combat and not to enable elder abuse. So by the end of June, we plan to publish the task force's next set of initiatives, so stay tuned for that. We're not done. And again, I want to thank every single legislator that is here today and who's going to be working on these bills and sponsoring these bills, and everybody who worked so very hard on this bipartisan legislation. The task force is incredibly grateful to all of you, and we look forward to continuing this work together to put in real solutions for those who are most vulnerable in our state. And so with that, we have a few minutes to take some questions. Right. Well, I'm going to have Catherine Barron come up and talk about that a little bit because she has been working tirelessly on that. So.
Thank you. And it was difficult to hear you from back there, so I just want to repeat, I think, what your question is. I believe your question is about due process, and does any of the legislation cover due process? Is that correct?
No, actually, the state public administrator process.
Oh, I'm very familiar with that because I am the state public administrator. This package of legislation does not address state public administrators.
Has there been any, I think you said a couple years ago that you were looking into that process. Has there been
We absolutely have looked into that process. I've looked into it very, very carefully, looking at all of our public administrators and making sure that their background checks are kept up to date and that we continue to monitor what they do and how they do it. So, and they've all received updated manuals that they have electronically, so if they have any questions about what they're doing or how they're doing it, they can do that old control find it or give me a call. They all have my direct dial. I can vouch for the fact that they all have my direct dial.
We made some changes too.
Yeah, absolutely, in the process. We have appointed a few public administrators, and we've looked at them all. So in terms of the changes, yeah, we interview each one very thoroughly. Now they have we've been doing Zoom interviews, as we've all been doing. And the background checks, I think they think we do everything except for take blood. And we were thinking about that, but decided that wasn't a good idea.
We've written some as well.
Yes.
Any questions over there? Lisa, do you have a question? Anna, any question?
I was just wondering if I could get a clarification. There's a note on here that one of the bills would establish a clear asset income threshold above which the appointment of a conservative is required. I was wondering if that could be explained a little bit more by whoever.
Yeah, absolutely. I'm happy to explain that. And I think what you're doing is you're looking at our initiatives number 8. And that's an absolutely great thing to do, because if you look at our initiatives, they explain what all the bills do. And so what we're trying to do there is find a happy medium between where guardians are appointed and conservators, because guardians can handle money. And so we want to make it very clear and come to an agreement on what that asset line will be, above which a conservator is appointed and must do some pretty robust reporting. Now, the challenge there is, when you have a conservator, that's going to cost money. So you don't want to set the threshold too low so that you're using all of the individual's money. They're not going to be happy about that either. But you don't want to set it too high that appropriate and reporting is not done. Now, guardians do have reporting requirements, and the courts can always require them to report more robustly. But we want to get some uniformity out there. And that's what you see in a lot of the legislation, because things happen differently in different probate courts. We want to make sure that they're all singing from the same hymnal, so to speak, and following the same due process and procedural protections. Good question.
We do have one from WXIC. They're watching the stream right now, and they would like to know how much did Heather Catellos' stories really resonate with the task force, and what was the impact of those stories?
Absolutely. Yes, so the question is, how much did Heather Catellos' stories resonate with the task force and us personally? Absolutely. The interesting thing about that, and why I believe it got the Attorney General's attention and our attention and ultimately my attention as the attorney that was responsible for that, is the family was all on the same side. Often you get families who are divided, and that's tough, because then you're in a position of, who do you believe? That family was all on the same side. The guardian ad litem gave a report suggesting that Marcy Mitchell become the guardian and conservator. So reports, they're clickers, right? They're Justice Klavanaugh's clickers. The media, yes, I like that. Oh, I sit up and look for a treat, but no, they absolutely, I got to be honest, they absolutely resonate with us. And so if you see something, don't be afraid to make noise. I personally have spoken to many, I want to say it's probably close to 75, nearly 100 individuals listening to their stories and advocates. Because if we're going to do this right, we can't have a myopic view. We got to listen to everybody and to come up with a solution. And that's the beauty of the task force. 100 individuals over 55 groups. Our view is not myopic. Our view is to solve this. So, quick answer, absolutely. Had a tremendous impact, and thank you for that reporting. That was very well done.
I have a question for the Attorney General. Sorry to bring you back up, but
That's all right.
I know that you said in March that you would not be going into an investigation about Dr. Robert Anderson because it would require full cooperation from UN and the celebration by the legislature. With new information coming out, are you reconsidering that, or are you thinking about starting?
Well, firstly, yeah, the question was about whether or not we'd be looking into the Dr. Anderson situation at the University of Michigan. I have a few thoughts on that. One is, obviously, in terms of the Nassar investigation and the goings-on at Michigan State University, you had potential defendants that were still living. And obviously, many of those cases took place decades and decades ago. Dr. Anderson is deceased, so clearly he cannot be prosecuted. It seems very unlikely to me, just first impression, that there are many living individuals that could potentially be subject to criminal prosecution. But moreover, but the biggest thing for me, and the lessons learned from Michigan State asked us to come in and do an investigation, and we did. And then they spent the entirety of the investigation stonewalling us. and not providing us with documents that were needed or producing too many documents, which was very time consuming. And of course, at the end of the day, ended up protecting over 6,000 documents that were deemed to be attorney-client privilege. And attorney-client privilege, that's a real thing. There's no question about it. It's a mechanism in the law where you can keep that information from an investigative agency. But why would we go into a situation knowing ahead of time that we would never really be able to get to the root of what went wrong at the University of Michigan that would have allowed this to happen if we don't up front have a Board of Regents that will say to us, when we say, full cooperation, that means full cooperation. And that means we will make available every single witness who you want to interview. We're not going to have our own attorneys there telling them what they should or shouldn't say and trying to intimidate them during the course of those interviews, which is what happened with Michigan State. And we're going to turn over every document that you want, irrespective of whether it is protected by privilege or not. And unless and until we get that kind of commitment, I will tell you right now, I won't waste the resources of this office, and I won't waste the resources of the state in order to conduct what would be an incomplete and inconclusive investigation. So for those reasons, I don't know that it makes a lot of sense for us to go in, nor have I been invited to. Now, I'm not going to say that every time we do an investigation we have to be invited in. Obviously, there's a lot of criminal defendants that would not open their door to us and say, why don't you come in and investigate and maybe prosecute us? I understand that. But of course, this is a different situation with the university because we know already from experience that there are a lot of hurdles that they can put in our way, a lot of obstacles they can put in our way if they choose to. That would really mean that we would not be able to get the answers for people that they so badly would like to know. But, again, if they do want us to conduct such an investigation and they're willing to abide by our terms, the regents at the University of Michigan have my number, except for Ron Weiser. I won't give him my number.
Attorney General, thank you.